Welcome to this panel on the future of structured sentencing. Obviously, the big theme for this panel is where do we go next? How can we improve the sentencing guidelines or just improve sentencing in general? So rather than introducing the panelists, I thought the images would be on the screen, but you have their names in the program. So we're just going to start with each one, and I think the idea is each one is going to say a little bit about what they do, what their organization does, as they sort of give their 5 to 7 minute sort of spiel on how we can improve sentencing. So Jonathan, should we start with you?
I'm happy to go first. I'm Jonathan Wroblewski. I'm the Director of the Office of Policy and Legislation in the Criminal Division of the Justice Department, and I represent the Attorney General on the Sentencing Commission. I'm just going to jump right in. Thank you, everyone, for being here, and thank you all for having me, especially the folks at the Council of Criminal Justice and the Ohio State University and all the others. It's a genuine honor to be here, and it's a joy to see so many people that I've worked with over the years. 2 warnings. One, the views I'm going to express are my own and not Merrick Garland's. And also, there's a little bit of math and science in my talk, so brace yourselves, lawyers. In addition to working at the Justice Department, I've taught most of my career. And one of the great joys of teaching is being around the young as they first encounter the law or some other subject. They are experiencing things for the first time, and when they do, they often experience a sense of wonder or horror, imagination, and possibility. Through the lens of the young, and also, frankly, through the lens of someone who's watched the federal system for decades, the sentencing reform process at the federal level very much appears stalled. There have been lots of changes for sure. I'll talk about that in a minute. But fundamentally, what the U.S. Sentencing Commission rolled out in 1987 is what we have from them today. And this conference, frankly, everything I've heard, I would have heard 40 years ago, at the 10-year anniversary of this, of the rollout of this book. I must say, in fairness, that the vision articulated by Judge Carlton Reeves, the current Federal Commission chair, just a few weeks ago, when the Commission amended its policy on compassionate release, has the potential of being quite groundbreaking. And if that first step, as he called it, leads to other reforms, the engine of reform may turn over again. I fear, though, that the Commission will revert to the posture it has taken for most of its existence, which is to lean on the false hope that new and better policies will result from tinkering with the existing guidelines by adding more and more layers of aggravating and mitigating factors on the framework devised by the first Commission. But whether or not you think the Commission has done a lot of good with the hundreds of amendments it has promulgated for the last 30 years or so, it is indisputable that amending the guidelines has dominated the Commission's work. The basic architecture and foundational principles of the federal guidelines have not changed since they were first promulgated, despite major and structural Supreme Court decisions, a bipartisan national movement to reform sentencing policy, dramatic changes to federal corrections law, including the introduction of a new earned time credit and risk assessment system, and unprecedented technological change that opens up great possibilities for sentencing and corrections. Now, I had the great fortune of meeting Marvin Frankel many years ago. I had just finished my second year at Stanford Law School, and I was working as a summer associate at Kramer-Levin. As I reread his book in the run-up to the conference, what is unmistakable about Frankel and what came back to me about that meeting is that while he was certainly intimidating, he was also humble. He was definitely sure of the problems he saw in the sentencing process, but he was far less certain of the solutions to those problems. And he approached the search for solutions with, as he said, humility and diffidence. But what Frankel missed in his book, and Judge Lynch, I think, spoke about this earlier today, was the dangerousness of his idea. Sentencing law without order suggests that the target is sentencing law with order. But the very idea of sentencing law with order is quite alluring. For prosecutors in particular, but for all of us seeking justice, a system that can claim to know just the right combination of punishment and mercy, deterrence and rehabilitation, incapacitation and redemption is irresistible. It is the Holy Grail. It provides an answer to the unanswerable, and it dangles the notion that we all can be Solomon. In the hands of those without Frankel's humility, those with a touch or more of hubris, a vision of sentencing law with order can lead to frightening results. Hubris and a belief that sentencing order could be developed led the first U.S. Sentencing Commission to the creation of a looking-glass world through which we as criminal justice community entered in 1987, and in which we find ourselves even now. Professor Paul Robinson, one of the first commission opinion leaders, saw the Sentencing Reform Act as, and I'll quote, an invitation to visionary reform, the sort of rare event that inspires men and women to their greatest accomplishments. Hubris indeed. His first draft of the guidelines was a serious mistake. It was mathematical and complex. It sought to account for every injury and harm, personal and societal, tangible and intangible, attributable directly or indirectly to the offender. And the sentencing world he created took sensible ideas like proportionality in sentencing and eliminating unwarranted disparities and twisted and turned them into upside down and distorted results. A hall of mirrors. The other commissioners actually recognize this. It's actually in the introduction to the first set of guidelines. But they realized it too late and not fully enough. The detail of what was ultimately enacted was built on Robinson's foundation, and it warped the entire search for justice. The distortions of acquitted conduct, the fraud table, the drug quantity table, and so many other problems identified during this conference and over the years owe in large order to the original guidelines design. And the Commission has been trying to fix those mistakes ever since, doing it by adding aggravating and mitigating factors of all sorts and all sorts of complex elements and tweaking various instructions. More than 800 amendments. Now, of course, sometimes more is more, and sometimes more is less. Professor Niro Sivanathan at the London Business School has written extensively about how adding a third or fourth rationale to an argument can actually weaken an argument rather than strengthen it. And so too, I would suggest with the guidelines. You would think 800 amendments would lead to more and more guideline sentences, but they have not. They have led to the opposite. There is a natural law of sentencing measurement defined by the elusiveness and complexity of sentencing justice. It recognizes a real and critically important limit on the ability of sentencing algorithms to produce consistent justice. The more accurately we try to measure sentencing justice, the more distortion we create, and the more unmeasurable it becomes. This inverse relationship between granularity of measurement and the ultimate outcome is not limited to sentencing. It is sometimes known as the Richardson paradox, named for an English scientist and mathematician. For certain disciplines, and I would suggest this is true of sentencing, instead of resolving into order and clarity, every closer examination reveals only more and more detail and variation. Prosecutors and defense attorneys know this instinctively about the search for justice. It's why the prosecutors refrain in opening statement, and we've heard this all many times, this is a simple case, while the defense lawyer stacks layer upon layer of complexity onto each and every action. The more granular we look, the less clear it becomes. It seems to me this paradox is especially true of the sentencing enterprise, and that simplifying the federal guidelines is not a worthwhile enterprise for simplicity's sake, but rather a certain level of simplicity in the sentencing framework will result in greater and more understandable justice. The notion of factor creep, of adding new factors, aggravating and mitigating, is precisely the act of trying to add more and more precise measurement of sentencing justice. The original design makes factor creep inevitable, and instead of getting us closer and closer to justice, it further distorts the whole criminal justice enterprise, and it ends up monopolizing the Commission's attention. Engine stalled. None of this, including our inability to craft perfect justice, should depress us. And none of this should diminish our idea of what the future of a sentencing commission can and should be. I think the new Sentencing Commission can craft a better set of federal guidelines. I think it can reimagine sentencing and corrections. I think it can conduct cutting-edge research. And I think it can start the stalled engine of reform. If it sees sentencing through the eyes of the young, the possibilities are vast. Thank you.
All right, well, first of all, I'm just so honored to be here. This has been a really great event and probably the most exciting event I've been to since the pandemic, and maybe one of the more crowded ones too. So my name is John Maki. I am the director of the Task Force on Long Sentences, the Council of Criminal and Justice. Part of my bio, you see, I'll speak from a perspective of someone who works in policy at the governmental, non-governmental level. I have a short PowerPoint here. I'm going to walk through. Here we go. So I want to give you an overview of the task force's work, what we were constituted to do, and I want to end with a kind of hopefully a provocative question that will resonate actually a lot with what you said, Jonathan. So the task force on long sentences, I realize I can't see this PowerPoint from here. We were convened to essentially do two main things: to assess the impact in a broad sense of our use of long sentences, and also out of that assessment to develop recommendations to advance safety and justice. I should note here, which I neglected to include on the slides, that for our working definition of a long sentence, we chose 10 years. No real science or precision behind that, but what was nice about it was it really forced us, it's definitely at the lower end of what a long sentence would be, and it forced us to kind of wrestle with really difficult questions. All right, to do this work, the council recruited 16 members from across the political spectrum, kind of embodied by our two co-chairs, former Deputy Attorney General Sally Yates and former Congressman Trey Gowdy. But this truly was a diverse task force, and it was both a joy and at times very frustrating to manage that process. Okay, next slide here. Oop. So one of the things about long sentences, which was pretty interesting, and as someone who's worked in kind of sentencing reform at the state and national level, I really assumed we knew more going in. There was a body of research we could kind of rely on, kind of just pick up. True and not true. Mostly not true. The research we have tends to be pretty dated. It's pretty, it could be focused in one jurisdiction. And so just even kind of grounding ourselves in the best research, the best evidence was definitely a bit of a task. And so we both internally and also recruited experts from across the country to kind of flesh out some of the big questions of long sentences. What is its public safety impact, or what do we know about its public safety impact? How do our long sentences compare to other countries? So this is a list you really probably can't see from where you're sitting, but I would encourage you, if you're interested, please come find me afterwards. They're all on our website. I think a big contribution, if I can say so myself, in terms of work that we produced. But here's what I want to talk about today. So we met for a year, about 10 full meetings, I don't know, countless subcommittee meetings, phone calls, group meetings. And we, it's about a month ago, we published our final report and recommendation, which includes 14 recommendations, and both includes kind of a research summary, a short essay, along with very extensive citations and a series of implementation steps. What I want to do now is not go through them one by one, but kind of highlight some of the key themes of these recommendations addressed. So I'll be skipping over kind of a lot of the meat of the actual report, which is in the implementation steps. And I would say here too, this was the fun and the challenge of doing this, is that we definitely tried to approach something like a comprehensive set of recommendations. And as you'll see, it goes all the way from kind of victim rights and services to prison conditions. So the first kind of big theme that we hit, or a series of themes, and these themes weren't really just focused only on these recommendations, they were carried throughout the recommendations, was safety, healing, and recovery. Public safety was paramount throughout our work, and maybe that's perhaps best exemplified in our first recommendation, which was about, I heard in the last panel, our use of long sentences, among other things, is very expensive, And so for any recommendations or implementation recommendations that would lead to the reduction of long sentences, we have a mechanism to reinvest those savings in programs that both reduce victimization at the front end, but also promote trauma recovery at the back end. We also wanted to see that same approach taken into the prisons themselves, and at all levels help to address victimization. And this is something, and I'll talk more about this towards the end, thinking about kind of where we, where Frankel began in the 1970s. Certainly one thing that we know now, or we know better than we knew in the early 70s, is the impact of victimization and the impact of trauma. And while this is still a developing field, we definitely know a lot more about, one, to how to assess people in terms of the trauma that they might have experienced, but also how that trauma can drive violence itself. Another thing that when Frankel was writing we did not have was victim rights. And usually I think victim rights, victim services are seen as the antagonists of sentencing reform. We really tried hard, both from the recruitment of the task force itself and all our meetings, to put those two into conversation. And so we wanted to make sure that we have victim rights throughout the country, especially in state constitutions, that we really take those rights seriously. That involved recommendations to assess the best practices in terms of victim impact statements, and especially how victims are, and this will be particularly important for any kind of second look reforms, how victims are made aware or brought into the process of those kinds of decisions. I think this is probably where we both critique a Frankel-like approach, but also expand on it, which is individualizing sentence. It's a key theme throughout the recommendations. It includes recommendations such as an expanded safety valve, sentencing not weights, but behaviors, and in particular, a more individualized approach to accounting for criminal history when someone is already facing a 10-year sentence. So I leave this one kind of on its own about addressing racial disparities. I'll say this was, not sure what the right metaphor to use is. Racial disparities, race in long sentences and ethnicity in long sentences came up in every single meeting. Often was fraught, it was tense. And I think what it really speaks to, it's the state of trust right now. And all of our recommendations, this is one we highlight, but all of our recommendations from a policy perspective, recommendation perspective, look to both diagnose the problems that are causing people to distrust government, distrust the criminal justice system, to address them, but particularly around race and ethnicity. These are back-end recommendations for people who are actually after their sentence, focusing on rehabilitation and redemption. Again, I think these are recommendations, as Jonathan said, I mean, many of these recommendations would not be things we probably could have even come up 40 years ago. But we looked at improving parole processes specifically for long sentences. Where am I here? Expanding the use. So one of the things that actually happened after Frankel is the contraction of sentence credits for people serving long sentences. Second looks, we encourage legislatures throughout the country to explore second looks for people serving long sentences. And lastly, we want to make sure that a lot of the second looks, a lot of policies that would look towards release, assume that there's going to be a prison system that can help people participate in programming. And so we want to make sure that the recommendations speak to the environment that people are incarcerated in. So as I noted at the beginning, it was stunning to learn how little we knew about long sentencing. Our recommendations, every single one of them includes an implementation step about making sure that we're researching outcomes, that we're collecting data, but the idea of learning itself was really important for the task force. And so we want to make sure this was even a standalone recommendation, that as whatever recommendations are implemented at whatever level, that we're seeking to learn from them. And I want to end with two more slides. I could have began the presentation with this slide, but I'm going to end with it instead. When the task force began about a year ago, we were really, without choice, forced to reflect on the rise in violent crime. And I think it was an important exercise because the sentencing laws and policies we have today were a product of a substantial rise of violent crime. And the question that we wanted to ask ourselves is, as we were facing our own crime spike, is, are we forced to simply repeat history? Go back to the well of long sentences, law and policies that were created in the 70s, 80s, and early 90s? Or is it possible to learn from what's happened, to look at the science of trauma, for example, to learn about what we know about the overlap between victimization and offending? And on that, I just want to end with a quick quote. I don't know if you can read this. I'm going to try to read the last part. So I'm kind of I was an intellectual historian before I got into policy work. So I always like to try to historicize what I'm doing. And for anyone who's done law and policy work in criminal justice and has tried to learn the history of it, you always find these moments where you find yourself in the history somewhere, where you find yourself, it's like a version of you staring back at you. And so early on, I was reading this. One of my favorite historians of prisons, David Rothman, another scholar, passed away in 2020, but from Columbia University. And I really wanted the last, I don't know if you can see that or not, I want to read the last. This was published in 1983. And this was a journal that was reflecting on not just Frankel, but really kind of the rise of sentencing reforms. And Jonathan, I think this kind of speaks to what you were just saying. David Rothman says, has a quantitative analysis been too warmly greeted at the table because the philosopher, the criminologist, and the historian too have run short of ideas, or even worse, reached a point of despair about affecting policy? Yet it is by no means apparent that the numbers will provide the answers. They might even help obfuscate the question. And so I guess what I want to end with is a question. Are we in a better position now to ask questions about what we're doing, to improve what we're doing, than we were 50 years ago? Thank you.
Good afternoon, everyone. My name is Marta Nelson. I'm the Director of Government Policy at the Vera Institute of Justice. And Vera has been around about 60 years. We rights and build safe. Speaking about the future of sentencing reform, and I'm not going to talk about the federal guidelines because I am not a federal practitioner, and looking at those grids makes my head want to explode. So I'm going to talk more broadly. Particularly, I'll just sort of give you a little sense about why me. I started off as a prisoner's rights lawyer, and then I worked in service, helping people get jobs when they come home from prison. And then I had an opportunity to go into public service in the government. So I worked in Governor Cuomo's administration for 5 years, started off on his reentry council, but then I segued into working on other criminal justice issues, including bail reform. Still being debated in the state, which is a whole other question. And notice that, as those debates around bail reform were happening, moving towards this legislation passed in 2019, there was a lot of momentum because there was a consolidation around a message, a narrative. Why do we need to do this? And the sort of the narrative at the time still is that money shouldn't equal freedom, right? You shouldn't have to pay in order to be free, because that's incredibly discriminatory and it doesn't seem right. Whoa, hello. Did you hear anything that I said before? Okay, good. So when I was there, I was like, okay, we've done bail reform. Yeah, right. At the time, we thought we had. And I remember saying, okay, sentencing reform. We haven't touched these sentences, these long determinant sentences that we put in place in the 90s. It's time. And people are like, oh God, I wouldn't touch that with a 10-foot pole. It's a third rail. And I realized that there was no commensurate vision for talking about sentencing reform. Like there wasn't something simple sort of appealed to people about what was wrong with the current system and what's a vision that we need to go towards. So, and I knew that this is intensely political. I mean, there was this conversation came up earlier in another panel about, it's absolutely political. I mean, you have to make an argument that's going to resonate with enough people who are then going to go and talk to their legislatures, and they're going to show up at state capitals with enough signs and enough phone calls and enough votes to make this happen. So you need something that's going to get people to care or to make a movement. And obviously this is happening. There's lots of organizing going on around Second Look in particular. There are campaigns. So the political movement is ongoing, but I still think we need to stop tinkering around the edges and think about like what is a vision for what sentencing could be that's going to get people off their couches. So we wrote a paper at Vera that just came out in February of 2023 called A New Paradigm for Sentencing Reform. And what we argue is that the future of any large-scale reform, and that will definitely include reform for violent offenses, that's the key, certainly in the state system, that's what's keeping people in prison, is that we need to rethink the purposes of sentencing. And I would say those four that we all learn in law school: deterrence, retribution, incapacitation, and rehabilitation. And we all talk about that because we're lawyers, but people out on the street, they're like, what are you talking about? What are those things? So as old as these are, we argue in this paper that the evidence does not support the assertion that these four justifications deliver safety or satisfaction as they promise. And in this report, we detail that, and we talked about this earlier today, that severe sentences don't deter crime, that retribution through long prison sentences often do not help crime survivors heal, and that as a rule, we overestimate who presents a current danger to the community and when incarceration is needed for public safety, and that rehabilitation, which does exist, things do work, Martinson, best occurs in the community and not in prisons. And then also just in terms of logic, if you put these theories together, and we've talked about that earlier today, it's not clear how they interact. They often contradict each other, and there's nothing that says, okay, you put these four together and that equals what, 7 years? I mean, it's not coherent. So we need a new sentencing paradigm, and it needs to be simple, and it needs to create a positive vision that resonates with how people think about responding to harm in their own lives when people that we care about create harm. So we need to start acting like we care both about the people who create the harm, the people who are harmed, and the future of the communities that we live in. So within that framework, we put forth 3 questions that legislatures should ask, prosecutors should ask when they're requesting a sentence, judges setting the sentences, and most importantly, the public, to whom everyone is supposed to answer. And here's the 3 questions. Does a sentence privilege liberty? Does it make individuals and communities safer, according to rigorous ongoing research about the nexus between carceral sentences and safety? And third, does it repair the harm caused by the unlawful behavior, informed by what crime survivors need? So I'll briefly describe the rationale behind these 3 principles, and then very briefly describe about what they might look like in terms of legislative changes. And the changes that we talk about in the paper dovetail a lot with the recommendations we've just heard from the Council on Criminal Justice, and which that report that they just put out, excellent, go read it. And other groups such as the Sentencing Project have put out similar recommendations. So the first principle, that sentencing policy should privilege liberty over incarceration wherever possible. So let's go back to the Constitution. The Constitution mandates that the government may not limit fundamental rights, such as liberty, without a compelling purpose, and must use the least restrictive means to do so. So you might say, what? You're using that for like a post-incarceration framework? That's not done in the courts. It's not. But why can't it be? And it could start with the legislatures. So we have departed from these precepts, but we don't have to. Why do we accept that a criminal conviction should extinguish the presumption of physical freedom? Instead, legislatures who create these laws can reclaim liberty and put it back on a pedestal, not to be knocked down except in the narrowest of circumstances, to assert constitutional principles to uphold fundamental rights for everyone. The second guiding principle is that sentencing must deliver actual, not performative safety. And those pushing for harsher sentences, and if you were following legislative sessions this certainly state and local, this session and the previous one, lots of pushes for enhanced sentences as a way to deal with the crime, the increase in violent crime, which is now going down, by the way. And this is by legislators who are looking to do something. They want to deliver safety. So they're like, okay, we're going to add a 5-year enhancement here, or we're going to make it harder to get out over here. And they're absolutely right to think that that's their job to deliver safety. I think that is true, that our state actors should be thinking about what makes communities safe. And I think that reformers need to lean into that as well, because we know a lot about what delivers safety. And we have ceded the ground to people who think that it's adding years to sentences when that is not the case. So we need to talk about what delivers safety. That community sentencing can deliver safety, not these harsh sentences that don't deter crime, and not our current overuse of incapacitation for people who don't present a current danger to others. And we should note that lengthening sentences is a tactic that legislators are using to say they're doing something about crime, while they're not investing in the strategies that treat trauma, which is a big cause of crime, and prevent crime. So, let's actually talk about safety and sentence with safety in mind. And third, sentencing should repair harm to victims. Now, crime survivors are not a monolith, and we need to continue to gather their perspectives. And that was one of the things I really loved about the CCJ report, is the emphasis on giving crime survivors what they need and responding to the harm that has befallen them. And I think that's absolutely right. But, to the extent that we know, and again, we need to do more, we have recent polling from the Alliance for Safety and Justice, which found that by a margin to 3-1, survivors of crime prefer holding people accountable through more proactive measures than incarceration, things like rehabilitative programming, mental health treatment, drug treatment, community supervision, community service. And that's because prison sentences are reactive. They're not proactive. And they don't necessarily help the crime survivor other than to remove the person from society, which may be necessary in some instances for a period of time, but not all. And so a proactive sentence would focus on what process, what actions, such as listening, apology, restitution, service, are needed to help repair the harm to a specific victim, if there is one, or to society to help that person grow and change so they're less likely to harm others. So what do these three principles look like in practice? It means that we really need to interrogate the rationale on a safety basis for sentences that are meant to deter crime, things like mandatory minimums. That'll be the reason that, other than the great power they give prosecutors, one of the reasons that mandatory minimums are out there, like it'll deter crime. Or things like second and third strike laws, right? You'll think twice before you do it again. That doesn't work. I mean, that's just not how people order their behavior, particularly the federal. We were just joking about this earlier. I'm thinking about committing a crime. Excuse me, I'm going to go check out this big thing that I can't read and decide to do that, particularly for crimes that are violent offenses. So we need to interrogate the rationale on a safety basis. In terms of liberty, how do we privilege liberty? We can cap sentences. We can create the possibility for community-based sentences across a whole spectrum of offenses. How do we do more repair? We focus on opportunities for repair for all. And an example of that is, this year California introduced, hasn't passed, AB 60, which would create a victim's right to be informed of and participate in a county-administered restorative justice program in lieu of traditional case processing. So this is an example of a legislative campaign built around these principles. And you can see building, again, political work, legislative campaign built on these kind of theories, and then, doing the work. It'll be years-long work, but then you want people to be able to answer those three questions as they're legislating. What about liberty? What about safety? What about repair?
So I think what we worked out ahead of time was trying to create a conversation between the panelists in conversation with each other before we open it up to the audience. So we're going to do that first. And I think one way I'm going to try to do that is I'm going to raise maybe 3 or 4 questions, maybe provocations, and just have you guys respond to anything or nothing, whatever. So as I was listening, several thoughts came to me. One was, how much longer do we want to tinker with the machinery of the criminal justice guidelines? Do we want to just, would it be better off if we just try to think of a blank slate and start again? Would that be better? Question number 2, and John, I was really thinking about this as you were speaking. So much of this conversation has been about sentencing reform, but can we talk about sentencing without also talking about prison conditions? Especially when you start off 10-year sentences, it's that really depends on what the prison conditions are. And related to that, we've been talking so much about public safety, and I always wonder if we're excluding the safety of prisoners. Are they the public as well? Third question, which I think applies for this whole conference, how do we get from here to there? What does that entail, especially given the various political climates? And the fourth thing I will mention, and I was really thinking about this, Marta, as you were speaking about the rationales for punishment. Because I have to say, if you were one of my students right now, I will tell you my students at Fordham, at Yale, at NYU, at every place I've taught, for them, when we discuss the rationales for punishment, they want to talk about abolition. So should that be part of the conversation as well? So I'm just throwing those out there. The floor is open.
I'm happy to start, but that's a lot of topics that you threw out, so I'm not going to touch on all of them. Should we tinker or not? I can say very definitively, I sent a letter on behalf of the Justice Department saying, no, we shouldn't, that we should go, that at the federal level, the Federal Commission should go on a little bit of a listening tour and see what's working and what's not working. They shouldn't take my word for it or any particular person's word for it. So in addition to some tinkering, which I think they have to do, and I think they probably can do at the same time, I think they should begin a conversation that goes beyond the people in this room and start thinking about what something new would look like. It's an enterprise that might take 5 years in total to get to the new enterprise, which would include, as was said before, convincing legislators and coming up with taglines. I mean, my tagline was more like safety, accountability, restoration, and redemption, but it's close enough to yours. So yeah. And how do we get there from here? Again, I think starting that conversation, and I think sentencing commissions are in a great place to begin that conversation, to lead it, to gather people from all across the criminal justice community, whatever that means. So I think that can be done. I'll leave prison condition. I'm happy to talk to the others, but I'll stop there.
I guess just to be provocative about the blank slate, I mean, it's very attractive. The idea every problem we have, we need to start over again. I think it's also a pretty American approach to things. Frankel has this in his book. I think it's what's so attractive. As Americans, I think we have a healthy skepticism and criticism towards the government. I don't know if that works too well in terms of doing government. And so I don't know. I'm putting that more to be provocative. I don't know if, despite all the problems that our system has, if the right approach is to kind of to say we can wipe it away. Because I just don't know if that ever works that way. And I think we might end up with something worse quite easily. So leave it at that. I think that I really appreciate the question about prison conditions. I think in a similar way, I think a lot of times reform does not consider that there are people in prison and they're going to be in prison. I was a prison watchdog in Illinois, and that's kind of what I always go back to in my mind. And I think about it in terms of course, the people who are incarcerated, their families, but also the people that work there. And I think there are so many meaningful improvements we can make in people's lives by focusing on prison conditions, by even, one of the things we didn't get to in our task force, which I probably would have been really hard to get to, was even reintroducing something like furloughs again. One of the things we definitely left behind, in that kind of Frankel, if you want to divide criminal justice between Frankel and after Frankel, is prisons were much more porous places, for good and also for bad. But I think there's lessons to be learned about how to do that safely to help people, again, have more human lives inside prisons. And I think finally, it could be a little bit of a cart before the horse thing. Maybe with more rehabilitative prisons, doing rehabilitative sentence work would be much, much easier.
I think on the federal side, I mean, it's so hard to legislate federal sentencing reform. I mean, my heart goes out to people doing that. I mean, the fact that things like the acquitted conduct law and the COVID-19 safer detention, all these 3 sentencing bills didn't get passed, like when there was democratically controlled, just breaks my heart. And they weren't that great bills, but they're better than nothing. So I kind of like this idea of listening toward on the federal side, because you're doing educating and you're just sort of going back to some very basic principles. And like, I'm sure people don't know how most people don't know how it works. They don't understand this grid, all this, like everything that we're learning today now, like, where's Joanna? Like the fact that you have to pay for your public defender in a lot of states. Like there's a lot of education to be done to just build up the sort of sense of this isn't rightness that is needed to make change. I think that a lot of it depends on how your understanding of how campaigns work. And I'll say in New York, and I think that's true in a lot of states, like there'll be a criminal justice reformer, lots of different reforms, and they kind of they get in a queue, right? You got a couple of years to like build up the campaign, and it moves to the front of the list, and then the leadership knows that it's there, and you have to really push for it. And so my concern, my fear on sentencing reform would be, let's say we go for something that's considered more low-hanging fruit, like a second look bill, which I definitely support for all the reasons we talked. But if that's it, and we get like it goes through the queue, and you get your 3 years, and then that's it, that would distress me. So my own preference would be to swing higher, at least in some states. You pick some states where the politics are such that you could do that. Then you study that, and then you just continue to build the narrative that and bring that to other states. But I think you got to swing a little bit higher. I mean, like continue on the fight to eliminate mandatory minimums for a bigger variety of crime than drug offenses. I think going after criminal history things like habitual offender laws, I think there's a lot of narrative that's been done around that, and then you get some wins, and then you use those to build other wins. And in prison conditions, I mean, I started off as a prisoner's rights lawyer, and I mean it's appalling. And I think that has to do with this sense of, like somebody said earlier, throwaway people. And the more that you sort of wrestle with what are we actually doing when we sentence someone, and having it be a proactive, forward-looking vision, you can't have throwaway people. Like what happens in that prison should be part of the repair, part of safety, and the conditions have to be such that that can occur. And so if you build it all into the narrative, hopefully, again, I understand how the real world works, but there's you make that part of the narrative.
So I take issue a little bit with your diagnosis of the problem. I believe that you're absolutely right that DOJ, and I think I mentioned this in the last panel that I was on, is regularly asking for +2, +2, +2, and the defense lawyers are asking for -2, -2. And frankly, over the years, the Justice Department has succeeded more than the defense lawyers. But I suggest that that's a symptom, not the problem, that the problem is the structure. Because it's not just DOJ that's asking for +2, +2. Members of Congress are asking for +2 and +2. Fentanyl is a problem. The guns were a problem last year. Violent crime involving firearms. And what did Congress do? They told the commission, raise the penalties, +2. Straw purchasers, +2 for trafficking. And yes, There are now defense attorneys in Senator Durbin's office, so they said also throw in some mitigating factors too. So you got more aggravating and more mitigating factors. I think it's just the nature of the structure. And if you look at the state sentencing guideline systems that have a very different structure and categorize crimes primarily by offense of conviction into 8, 10, or 12 categories, those kinds of fine gradations, the constant tinkering with the dials, disappears because it doesn't make sense. The initial structure put together by Paul Robinson said we can constantly tinker with the dials. And that's the basic structure that we have. And as a result, yes, the DOJ prosecutors, and that's true of the Civil Rights Division, the Tax Division, the National Security Division, everyone, and the members of Congress, the political branches are going to want to do what was suggested, which is to do something about the crime problem. And we need the commission to say, as some of our colleagues said this year, this isn't going to actually help the problem. But if the structure constantly pushes that possibility in front of members of Congress and in front of the political branches, that's what you're going to get. And I think if the basic framework is restructured, you're going to get less of that because it will make no sense to ask for 2 levels for someone who sells fentanyl if it's in this particular form. Yes, you'll get a penalty for selling fentanyl, but the fine gradations, that's what I think can disappear, and I think the whole dynamic can change. I'm happy to keep talking. Thank you so much for your question. In the 1970s and 80s, we created a system that put a tariff on a crime. It said that if you committed a crime, you get a certain punishment, and the scale of the punishment was based on number of months in prison. I don't think that was the right answer, and I think it goes to the heart of what you're talking about. And the only way to change that is to change the scale and the way people think about punishment. And this is what was described before. Instead of saying, okay, somebody committed a crime, let's look at the table and what the tariff is and the algorithm and come up with a number, 27 to 32 months. Okay, that's one way. And the other way is safety, accountability, restoration, redemption. And I wish I could make it happen tomorrow. I really wish I could. And trust me, I've been trying to make it happen for some time. The only reason I'm saying it may take 5 years, because if we're lucky, it will only take 5 years. But I just think we ought to start today and try.
Yes.
And how many months is safety, accountability? It's ultimately how many months?
I don't think so. I don't think you're suggesting you've been brainwashed. You walked through the looking glass in 1987 just like the rest of us did, and you think that the answer is a number of months in prison. The answer depends on the crime, the person, the victim. It's complicated. The question of what is justice is complicated and is unanswerable at the end of the day. And the idea that we're going to come up with an answer that fits right here, right now, in this spot, for every situation that involves a burglary is the false hope, which I think Judge Frankel forgot might happen. And that's what happened. We found a person, his name was Paul Robinson, a nice man. He meant very well. But he said, we can come up with an answer in a number of months. And we've all been through that looking glass, and we all are thinking like you, Judge Edelman, and we have to think in a very, very different way.
Yeah, and I would echo that. And I think it was Professor Berman who said today that we came up with months because it's something you can literally fill into those boxes. And we didn't have a different structure nearby because we think in terms of incarceration. So it's like, okay, what should the punishment be? It's going to be some time behind bars. The question is how much. And we weren't thinking about, okay, well, maybe it's some form of community service. Maybe it's some form of some sort of a restitution process or some sort of a listening process or something like that. Like other things that address the fact that this harm occurred and that there needs to be accountability, but it doesn't equal a certain number of months in prison. And that's where this idea of liberty comes in. Like, you should, before you take away somebody's liberty, you better have a really, really good reason. And therefore, you don't fill in those boxes with numbers. You fill in those boxes with other kinds of tests that can hopefully happen in the community. Not in all instances, but in many of them. And if we don't have the answer now, it's because we haven't really tried as a country, certainly over the last 50 years, but that doesn't mean that we can't. I think it's just this idea of like, okay, put that paradigm aside, start talking about another one, and then figure it out together through a democratic process, which is how we're supposed to make laws that affect people's lives here.
I know John wants to respond, but I just want to add one wrinkle to the question. It seems to me that we could easily say we're actually heading in the opposite direction of what everybody's been talking about. It seems like looking into the future, we're more likely to go to like algorithmic justice, which is more like more factors, but here's the perfect output, here's the months, rather than something more nuanced like we're talking about. But John?
Yeah, I love this conversation. I like what you said about there is no way to quantify justice in my view. And Judge Edelman, I so appreciate your comments in one of the breakout sessions. I took that to be your point. I guess I want to say, and it goes back to kind of I have a historical way of thinking of this. And we haven't been doing this that long. It feels like a long time, but we've as a civilization, we've done torture, quartering, banishment far longer. This is still like new stuff. And that does not answer the question, though, and the urgency of cases like yours, where your life is imperiled. And I wish I had like a nice answer to bring those two together. But again, I would say I think it's I think history shows is when we think we know what's going to happen tomorrow, and we know all the right things to do. It doesn't work that way. And I think about this period in particular that Frankel was writing in. No one saw over-incarceration coming. No one, and no one could have seen where we are maybe before the pandemic. So last thing I want to say is you asked a really interesting question about your students and abolition. I'm 47 years old. I don't understand that as a value. I understand it as a philosophical problem, but clearly something's happening with the earlier generation, younger generation, and we might find ourselves in a very different world that we cannot see today.
Well, that I think was actually a positive note. So I feel
it could go south too. It could always go bad.
Please join me in thanking the panelists.